All right. Hello, guys. So here's the actual website for those of you who are curious. Um, this one is a link to the store. Yep. You can scroll up. All these unique items that you guys can get. Ordered one of these. Hopefully, it'll be here. Ordered one of these. I think I ordered one of these, although right now I think that was kind of dumb because weather's changing. It's been kind of cool today. So I'm wearing an actual t-shirt, not a tank like you usually see me in. But yeah, there's all kinds of neat stuff here. Stickers, gators, hats, making fun of some things. Still working on more. But yeah, you guys can come here, order this, order. Let's see, if you like. Most of it's like t-shirts and tanks, but there's a few other things as well. Yeah. So that's one way you guys can support me, and you'll actually be getting something for supporting the platform. Uh, go back to the website. You can see here, you've got the blog, all these nice fanciful writings. There's several pages within there. It goes back for quite a while. Podcast, as I said, everything is centrally located. More, take you all the way back to season 1. Videos. See the videos that I've done. Yeah, these two, I know the audio clips that I attempted to do, the audio didn't record. I'm sorry, there's no way for me to go fix that unless I go dig those clips back up and try to do a completely new recording. You can also click on contact. You can fill out the information in Messenger. We can have conversations. That should be fun. But down here, you'll also see, well, not down here, but up here, no matter what screen you go to, there's my links. You got Twitter. I think that goes straight to the podcast, Instagram, uh, LinkedIn, YouTube, so on and so forth. So there's that. Just wanted to get a little bit of whatever out the way. So I'm actually going to talk to you guys a little bit about Roe versus Wade. It seems to have come back in light in just about all news stories of recent with Texas. And this is how I do my research for civil and what is it? Sorry, criminal justice, civil law, and constitutional law. And this is actually the website most of my instructors have used. We come here, go to Oyez, I think that's how it's pronounced. You got your search bar where you type in the case that you're looking for. This one happens to be Roe versus Wade. They'll read it to you, although Roe versus Wade is old enough. There's not supposedly um, audio recordings, at least for the one that I was reading before. That's what it said. You can come down here and look at the syllabus. If you're a student in a class that's involved with this directly, then you have view case. And I'm not going to click on this, but this is where I would normally go, is view case. But the reason I'm not going over there is because I already have it open over here. And when you click on view case, it takes you to Justia U.S. Supreme Court, which is actually like Supreme Court transcripts that they write up and release. I have this nifty little program I had to use for one of my education classes when I was majoring in secondary education that you can turn on and off, and you can highlight stuff that you find on the internet. You can make notes, all this other fun stuff. And as you can see, I've highlighted. Now, these will actually stay here for other people to see if I set it up so that they can see it. But right now, it's just set for me. And this is the decision that the judges came back with on Roe v. Wade. And for those of you who aren't aware, the name Jane Roe is an alias because she was afraid of backlash with filing this case. Now, a lot of this, the first, as you can see, I'm in section 4. The majority of the sections, they go over the case and they talk about what the plaintiff said, what the defendant said, appellate, appellee, is the terms that they use. Very confusing. But we come down here, and this is where they start to justify why they took the case. And you've got your line numbers. You can click on them or whatnot. And then also you have your links to other cases whenever they reference other cases. This is actually really nice. It kind of helps for when you're studying or seeing how things are connected together, because the court is supposed to rule on precedent, which means they rule on a decision from a previous case or cases. So here we start off with the usual rule of federal cases is that an actual controversy must exist at the stages of the appellate and whatever that word is, review, and not simply at the date the action is initiated. That's in United States versus Munsingware Incorporated. Like I said, they'll give you a link right there, depending on how far down the rabbit hole you want to go. There's like 3 cases listed here. But when, as here, pregnancy is a significant fact in the litigation, the normal 266-day human gestation period is so short that the pregnancy will come to term before the unusual appellate process is complete. If that termination makes a case moot, pregnancy litigation seldom will survive much beyond the trial stage, and appellate review will be effectively denied. Our law should not be that rigid. Pregnancy often comes more than once to the same woman, and in the general population, if managed to survive, it will always be with us. Pregnancy provides a classic justification for a conclusion of non-mootness. It truly could be capable of repetition, yet evading review. Meaning that this case, technically the case could come up over and over and over again, same defendant, different defendant, whatever. But because of the limited time of the pregnancy, whether it follows through completely or it is terminated, there wouldn't be time to go through all of the appellate process, all the appeals processes. And so that gives them jurisdiction that even though she's no longer pregnant, to go ahead and hear the case and make a ruling on it. And then they have do's, don'ts, and other discussions about why it's fitting for them to actually take the case and review it. Section 5, principal trust of appellate's attack at the Texas statute. For those who don't know, Texas had passed a law that had almost completely at that point in time banned abortion. I just got some high points highlighted here and hopefully giving you guys some information you might not normally know. There is a lot of legal garbage in this. It is not easy reading. I will go ahead and tell you that now. For any of you guys who are going to go and research this and read through it yourself, I do highly recommend it. Gonna have times when you don't entirely understand what's being said. I've had several criminal justice classes and I still don't understand all of it. Just giving you a heads up. I hate lawyer speak. Here, 40 Texas NBC, the common law, states, yada yada yada. I didn't skip that much. Section 7, 3 reasons have been advanced to explain historically the enactment criminal abortion laws in the 19th century, because they're going through the history of abortion in the United States and abortion laws. They go way into all of this, and they did a lot of research. They actually talked to more people than just those that were involved in the case. Here we have, in assessing the state's interest, recognition may be given to the less rigid claim that as long as at least potential life is involved, the state may assert interests beyond the protection of the pregnant woman. Okay, let me back up just a little bit. Part of this debate and discussion is the right to privacy, because Jane Roe filed this court case in accordance with Fourth, Fifth, Seventh, the Ninth, that highlighted already. It's not highlighted because it's farther down. Probably farther down. There's several amendments to the Bill of Rights, or from the Bill of Rights, that she filed this under, which was she was trying to get, or I guess her lawyer filed under. Her lawyer was trying to get it seen as right to privacy, as well as the privacy between patient and doctor privilege. And while the court is acknowledging that, yes, to a certain point, that has an effect, at the same time, anytime the female, the pregnant mother, leaves the house, it is no longer a right to privacy, because at a certain point, you can see and tell that she's pregnant, and that's in public view. So it does and it doesn't fall under right to privacy. They also argue for due process. On the basis of elements such as these, appellant and some amici argue that the woman's right is absolute and that she is entitled to terminate her pregnancy at whatever time, in whatever way, or for whatever manner, reason she alone chooses. With this, we do not agree. Appellant's arguments that Texas either has no valid interest at all in regulating the abortion decision, or no interest strong enough to support any limitation upon a woman's sole determination, are unpersuasive, meaning they didn't convince the court of it. And that was part of the reason why they didn't convince the court of it, is because once she starts to show, as we say in these modern times, and she's out in public, it's no longer right to privacy. It's known to everybody. It's in public view. More about cases in reference to that, where certain fundamental rights are involved. Court has held that regulation limiting these rights may be justified only by a compelling state interest. And a lot of court cases involved in that. And this is where they're arguing that there could be a compelling state interest in the person, in the baby, the fetus. All right, so the appellee and certain amici argue that the fetus is a person within the language and meaning of the Fourth Amendment. In support of this, they outline the length and in detail the well-known facts of fetal development. If this suggestion of personhood is established, the appellant's case, of course, collapses, for the fetus's right to life would then be guaranteed specifically by the amendment. Henceforth, why the Constitution starts out life, liberty, pursuit of happiness. Then here they're arguing that the Constitution does not define person in so many words. Section 1 of the Fourth Amendment contains the word person, defining citizens. It speaks of persons born, naturalized, but it doesn't say anything about pregnancies other than being born in the U.S. It doesn't say about while you're gestating. Word also appears in the Due Process Clause, Equality Protection Clause, so on and so on. Here, while the word is used several times, not several, a few times throughout, and it's used in the, I guess you could say, newer, new-ish, more recent amendments, such as women's rights, the right to give, that gave African Americans the right to vote, freed slaves, so on and so forth. Let's see, all this together with our observation supra that throughout major portion of the 19th century, prevailing legal abortion practices were far freer than they are today. Persuades us that the word person is used in the 14th Amendment does not include the unborn. This is in accordance with results reached in those few cases where the issue has been squarely presented. And they go on to discuss that more, referring to several clear cases. Right here, B, pregnant woman cannot isolate in her privacy. She carries the embryo and later a fetus if one accepts medical definitions of the developing young in the human uterus. And for that, they used Dorland's Illustrated Medical Dictionary, and they list the pages that they used it. 24th edition, printed in 1965, which this was a 1973 case. Situation this therefore is inherently different from marital intimacy, bedroom possession of obscene material, or marriage, or procreation, education, with which Eisenstadt and Griswold, Stanley, Loving, Skinner, actually Loving is a very, very interesting case. You guys go look that one up. That one's related to interracial marriage in Virginia. I believe it's the state of Virginia. Good case. I enjoyed reading that one. Skinner, Pearson, Meyer were respectively concerned, as we have intimated above. It is reasonable and appropriate for a state to decide that at some point in time, another interest, that of health of the mother, or that of potential human life, becomes significantly involved. The woman's privacy is no longer sole, and any right of privacy she possesses must be measured accordingly. So Texas urges that apart from the 14th Amendment, life begins at conception and is present throughout pregnancy, and that therefore the state has a compelling interest in protecting that life from and after conception. They're arguing about life begins at conception. Now, big science background here, medical background, associated science, biology, microbiology, and whatnot. Anything made up of cells is considered alive. A single-celled organism is life, and it's considered alive. Viruses are debated. There's no definitive answer to that. But even a single-cell organism is considered alive. So when the sperm and the egg meet, and they're enveloped, and they combine DNA, at that point in time, that is a single-cell organism. I don't know why, and they knew this back then. I think that was something that was discovered in the 1800s. So I'm not sure why they're debating when life begins. Because as soon as it's a single cell, let alone when it divides and it's two, that's life by scientific definition. It might not be defined as human, but it's still alive. So yeah, I got a little bit of an issue there. But we're also talking about a group of lawyers, not people with science background. And they actually acknowledge that as you read through this. I don't think I highlighted that, but they do. They acknowledge the fact that we don't know anything about biology or science, which is why we talk to other people outside of the case and read books. Let's see, did I read that one already? Yeah, I'm down here. Second one. We need, yes, we need not resolve the difficult question of when life begins. Actually, I just solved that one for you. There are scientists back in the 1800s when they discovered cells that life is, single cell organism. Not only does it react to its environment, but it also acts upon its environment. That's life. When those trained in the respective disciplines of medicine, philosophy, and theology are unable to arrive at any consensus, the judiciary at this point in the development of man's knowledge is not in a position to speculate to the answer. That's their shortened version of saying, we don't know science. It's not our thing. We interpret Latin written laws. But I believe that does come up again. They do if you read this word for word, they do say straight up in there, medical and biological and science is not our thing. And so we referenced and we spoke with X people. They list them by name. They also list the books. They're very detailed in this. They have to be. They actually have to be. You see, this is where this is also somewhat important. It should be sufficient to note briefly the wide divergence of thinking on this most sensitive and difficult question. And they go into the history of that. There are people who argue life begins at conception. Some say that in the past, it was said that life didn't begin until the quickening. Quickening was the first time the baby moved and the mother felt it. Because the baby's moving around all the time anyway. It's when the baby moves and mother can feel it, or somebody else can put their hand there, such as dad, can put their hand on the belly and they can feel it when the baby moves. And the baby reacts. I've got 3 kids. I loved playing with them while they were in my first wife's belly. It was fun. Can't say that they enjoyed it, but I did. They reacted to it too. Well, they also reacted to my voice when I was home. And see, that's another sign. They moved and they reacted just from hearing my voice, which means that they recognized it. But yeah, so like Renaissance and medieval times, they used the quickening as that's when life is. And their theory was the first time the baby moved and was felt, the religious theory and doctrine was that was because the soul had finally entered the body. And yes, if you read word for word, they talk about that in here. Because, like I said, they do a lot of history in this ruling, a whole lot of history. Let's see. Large segment of the Protestant community, so far as ascertained, organized groups take formal position. Abortion issues have generally regarded abortion as a matter of conscience of the individual or family. We have noted common law found greater significance in the quickening. What it is, I'll find it for you. Physicians and their scientific colleagues have regarded the event with less interest and have tended to focus either upon conception, upon live birth, or upon the interim point at which the fetus becomes viable, which means it can survive on its own, sometimes with medical help, and doing their research, survive outside the mother's womb. At this point in time in 73, it was 28 weeks with applicable as low as 24 weeks in some cases. Nowadays, it can be under 20 weeks. 20 is about average. There are some that are under 20 weeks who they have been able to keep alive for one reason or another. The Aristotelian theory of immediate animation, basically that's going back to the quickening, held throughout Middle Ages, Renaissance in Europe, continued with official Roman Catholic dogma, 19th century, Then they talk about how the Catholic Church has changed their belief. Catholic Church, who would recognize the existence of life from the moment of conception. The latter is now, of course, the official belief of the Catholic Church. It's a view that's held by some, not by many non-Catholics, but not all. Areas other than criminal abortion law has been reluctant to endorse any theory that life as we recognize it begins before live birth. Again, this is in 73. Of course, we still have those people such as New York, you know, abortion at any stage, even the day before you go into labor or as you're in labor. Was it South Dakota? I want to say it was South Dakota was in the news recently. There was a bill put on the Congresswoman's desk that required medical providers to give life-saving and medical treatment to those babies who were attempted to be aborted but survived and were born alive. And she has refused to sign it. She doesn't want to touch it with a 10-foot pole, which I don't understand that, because if they attempted to abort the baby and the baby's born and it's living anyway, then he or she is viable and should require, and medical providers should be required to provide medical treatment and attention. That's my opinion. I mean, kids survived. Obviously, they are fighting for survival. That is a reaction as well as an action put on the earth. That's a reaction from their environment as well as acting on the environment itself. And I heard somebody say it this way earlier today. I've never thought of it that way. But why, if you tried to abort a baby and it's born and it's living, breathing, what doctor is going to, after taking his or her Hippocratic oath, and smash the kid over the head? Well, you know, mom doesn't want it, changed her mind, crush the skull. Which honestly, you can cave a baby's skull in with your hand when it's first born, because the cartilage pieces haven't fused to form the skull, and it's soft cartilage. Not real science and biology there for you. It's one of the reasons why you always have to support the head. They tell you to be careful, don't let the head get bumped, so on and so forth. Newborns, when you're holding a newborn, you have your fingers up here, you can actually feel the soft spot in the middle, kind of a little bit towards the back, where the plates have not come together. It's completely open. That skull-wise, it's completely open, not a freaking head. Freaking head's not open. Don't be that dumb if you're listening to me, because I got no hope for you. In view of this, we do not agree that by adopting one theory of life, Texas may override the rights of pregnant women that are at stake. We repeat, however, that the state does have an important and legitimate interest in preserving and protecting the health of the pregnant woman, whether she be a resident of the state or a non-resident who seeks medical consultation and treatment there. And that it has still another important and legitimate interest in protecting the potentiality of human life. These interests are separate and distinct. Each grows in sustainability as the woman approaches term and at the point during pregnancy, which becomes compelling. So here they admit, and later on the argument is, yes, she does have a right, because we don't know when life begins, and our own medical science and people and persons and theologians can't come to a unanimous decision about when life begins. We can't necessarily make a ruling in favor of the state, completely against abortion. But at the same time, they do acknowledge that there is a point in time in the pregnancy that the baby is obviously alive, obviously reacts to their environment, and has an effect on their environment, which their environment is the womb, their environment is also the mother. They have an effect on the mother. And because of that, it's not really a potential human, it is a human, and that needs to be addressed. Because the fact that it's a potential human does give the state a valid point of interest and a compelling argument. That's what this is about. And to be perfectly honest, if you go back, you don't even have to use medical books. Although if you really want me to, I've got an advanced EMS book there I can pull out and show you pictures. The thing is so worn because I've used it so much. I constantly pull that book out and use it. But in the book, they actually discuss and talk about the different stages in pregnancy, because in EMS we do have to deal with pregnancy, and it's very, very rare, thank God. There are times when you have to deal with saving the child, saving the mother, saving both, making a choice. And part of that making a choice is also the choice of the mother, because I mean, even in a hospital setting, there are times when the mother's in distress, goes into labor, and the mother says, I don't care what happens to me, save my child. You have to follow the mother's wishes. At the same time, if you're on an ambulance, mother's in labor, you are, for the most part, according to the book, you're dealing with one patient until the baby's delivered. If the baby is delivered, now you have two patients. You have to split your time between them both, and the majority of the time you're giving priority to the baby, because that's more of a hazardous situation, so to speak. We try to keep the backs of our trucks clean. We sterilize them and clean them up between calls, but there's always the possibility of something being missed. Not to mention not to mention the mess that a delivery in the truck makes on the truck itself. All right, this means, on the other hand, that for the period of pregnancy prior to this compelling point, the attending physician, in consultation with his patient or her patient, is free to determine without regulation by the state that, in his medical judgment, the patient's pregnancy should be terminated. They're talking about medical reasons for terminating a pregnancy, so on and so forth. State regulation protective of fetal life after viability status has both logical and biological justifications. If the state is interested in protecting fetal life after viability, it may go so far as to prescribe abortion during that period, except when it is necessary to preserve the life or health of the mother. Measures against these standards, Article 1196 of the Texas Penal Code. They break this stuff. Like I said, they really break it down. I believe that it was argued 1194 through, no, it was 1190 through 93 or 94, and then 1196, I think 1198. But all that's up there at the top too. I mean, if you're really interested, because this really is a fascinating case. I mean, I've heard people discuss it, and I've heard people say blah, 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 blah. Even today, there are some people who argue that Roe versus Wade, who don't know anything about the case whatsoever, they argue that Roe versus Wade is law. Well, I hate to break it to you, but Roe versus Wade is not law. The Supreme Court does not have the ability to make law. The Supreme Court interprets law. Three branches of government, guys. Three. You have the legislative branch, which is Congress. That's your House of Representatives and your Senate. You have the executive branch. Sorry, legislature makes the laws. You have your executive branch, that's the office of the president, and their job is to enforce the law. That's it. Despite what all this stuff coming out of DC is right now. Okay. This is what's in the Constitution. This is what the powers divided up in the Constitution. The Constitution says. And then you have your judicial branch, the United States Supreme Court, who interprets the law. And you're supposed to interpret the law as written. Excuse me. Y'all really weren't supposed to hear that. There have been attempts in the past where the Supreme Court has tried to make laws. They don't have that power. There are times in the past where the presidential office of the president has attempted to make laws, sometimes using executive orders. Again, they don't have that power. Their power is to enforce the law. They determine how to enforce it. That's where your executive orders come into play. Laws are made one of two ways. They're either voted on and passed in a bill through, which is supposed to start in the House of Representatives and then goes to the Senate. Or they can be done by an amendment to the Constitution, which the one way to amend the Constitution everybody knows about is Constitutional Convention called through the Congress, which we all know that ain't gonna happen. But the other way that a lot of people don't know about, I believe it's the fifth, I believe it's Article 5, is what's the correct phrase? State convention. If you get 34 states who petition on the exact same item, that forces Congress to do a convention of states or constitutional convention, but it forces the Congress to call one. They don't have the ability to say no. If you get 34 or more states who sign up, request a convention on, now here's the key, it has to be all 34 of them or more, all have to be addressing the same issue. You can't have like 4 states want to amend the article for voting, 10 states want to amend the article or create an article in relation to abortion. Another 20 states want to create an article to take powers away from the presidency. Now, technically, that gives you 34, but you're looking at 3 different categories. Not going to happen. They all have to petition for the exact same subject debate. And they have to, once that convention is set, when people get there, that is the one and only thing they can talk about. They can't have a convention to discuss voting or have a convention to discuss freeing the slaves and then turn around and say, we're going to abolish drinking. They can't do that. And that's in the Constitution. The Constitution does talk about that. I read it. I actually think I've talked about that with you guys too. I know that there's some stuff that I did not too long ago involving the yes. All right, where was I? Sorry, I get word block easily, but I'm trying to help you guys as well as try to help myself. Actually, part of it is I'm trying to get some of y'all interested so that you can go and do your own research on this. I would love, I've said it before and I'll say it again, I'd love to hear back from you guys, especially doing your own research. And if you go through and you read something in the Constitution, in one of these court cases, whatever, and you interpret it different from me, I would love to hear from you as far as what you interpret it as well as why you interpret it differently, see it differently. Anyway, yeah, going back to Article 1196 Texas Penal Code. In restricting legal abortions to those procured or attempted by medical advice for the purpose of saving the life of the mother, sweeps too broadly. The statute makes no distinction between abortions performed early in pregnancy and those performed later, and it limits to a single reason, saving the mother's life. They're saying that that being the only reason why abortion could be performed when this law was passed in Texas, no good. You have to distinguish the time period and justification. Limits the reason saving the mother's life, the legal justification for the procedure. The statute, therefore, cannot survive constitutional attack made upon it, or made upon it here. This conclusion makes it unnecessary for us to consider the additional challenge to the Texas statute asserted on grounds of vagueness. See, what it is at this point in time, the Supreme Court, when a case was filed and it made its way all the way to the Supreme Court, there's several different articles within a single statute. Well, at this point in time, and I honestly don't know when it changed, I believe that was something that the judges decided to do, and I don't agree with, but maybe Congress passed something, and I'm not aware of it. At this point in time, if a single article in a state law was found to be unconstitutional by the Supreme Court, that entire law was unconstitutional. What they're saying here is that Article 1196, the justification for abortion, the limit as to time frame is too broad, and the reason required in order to medically allow an abortion is too narrow. Because of those two things, too broad up here, saying no abortions, too narrow down here, saying the only reason for an abortion is to save the mother's life. This is too broad. It's not defined. It needs to be narrowed down. This is too laser focused. And with that being, that makes 1196 unconstitutional. One unconstitutional article within the entire law makes the entire law unconstitutional. We've had rulings come out recently, and we really saw it when there were arguments in court cases fighting against the Affordable Cares Act, aka Obamacare, where they struck down sections of it and not the whole thing. Well, technically, unless Congress made an adjustment in the powers of the court, the entire Affordable Care Act should have been struck down as being unconstitutional, not those sections. Again, personal opinion. But it follows the argument right here in this case, first of all. And second of all, like I said, Congress may have passed something, some kind of a bill or a statute that allowed the court to strike down sections instead of the entire law. I don't know. I'm not quite that caught up, maybe. Honestly, guys, I've got such a broad interest of stuff that when I research, when I get the opportunity, yeah, I don't have time for everything. Like, come on. There we go. See, I just read this today. No, not communist, not socialist either. I read it because I'm writing about it. yeah, title's gonna change somewhat. I've got to get the writing started and see where it goes. But yeah, so that'll be interesting. And this is my own personal project, so this is something that'll be up on the website. This is not for school. Um, for school, for those of you who might be interested. Hmm, yeah, here it is. This this is for school. It's a rough draft of something I've got to write for them, and we're going to edit it together in class. Well, not in class, through discussion board because I'm not physically in class. Um, but we're gonna do some editing with it, rewriting with it, per others' recommendations. Maybe once the final draft is turned in, yeah, it'll probably go up there too. So, uh, hmm. All right, guys, we're gonna take a quick break. Okay, I'm back. Sorry, I had to run and get more fluids. So yeah, I really needed to step away. In case you guys haven't noticed, I'm clearing my throat, coughing a little bit. Smoker's cough. Recommend don't starting. I get like 2 or 3 phone calls from MUSC and the VA a day wanting to know if I want to quit. My answer is no, I enjoy it because I do enjoy it, but still have smoker's cough. Oops, I didn't do that. Yeah, you guys get to see everything I have open on my computer now. As I, and that was the background behind the scenes of the store. And yeah, the store is driving me absolutely nuts. Sorry, guys. I'm still having issues on the backside of it. Looking at my emails. All right, so we're back. Uh, yeah, where was I? All right, well, let's see. Statute makes no distinction between. Oh yes, part of the statute is too broad. Part of it is way too focused. Um, so to summarize and to repeat, the state criminal abortion statute for the current Texas type that accepts that accepts from criminality only a life-saving procedure on behalf of the mother without regard to pregnancy stage and without recognition of the other interests involved is violative of the due process clause of the Fourth Amendment. A, the stage prior to the approximately the end of the first trimester, the abortion decision and its effectuation must be left to the medical judgment of the pregnant woman's attending physician. B, for the stage subsequent to approximately the end of the first trimester, the state, in promoting its interest in the health of the mother, may, if it chooses, regulate the abortion procedure in ways that are reasonably related to maternal health. Part of the argument was when they were digging up there and doing research on the history, abortion laws previously, when enacted by states, which almost every state had some kind of law regulation, or actually multiple laws, regulations, and so on in regards to being able to have an abortion, wasn't banning abortions, but it was regulating how they were done because so many people in general were doing abortion procedures for women and a lot of them didn't know what they were doing. and a lot of women were dying. And so states were putting in regulations talking about it needed to be done in a hospital, needed to be done by a licensed physician, needed to be done, this, that, and the other. That's what B is referring to. C, for the stage subsequent to viability, the state is promoting its interests in the potentiality of human life. May, if it chooses, regulate and even prescribe abortion, except when it is necessary and appropriate medical judgment for the preservation of life or health of the mother. See, and this is the part that a lot of people, this is why you really need to get down and into these court cases, especially the ones that people reference all the time. These judges, when they made this ruling, said, because we don't know what the viability stage is, because we don't know when the actual semi-consciousness takes effect, when the baby's able to sense, hear, feel, and so on, even though the state does have a vested interest in the protection of that baby's life, the state can't just turn around and say, well, we don't know when it has an actual effect on the baby and its consciousness is gonna, feel pain, be tortured. So let's just say if you're pregnant, you can't have one. The court says you can't do that. Because even though there's potential for human life there, you don't know that it's going to be a human life because the mother's body may choose to evict it anyway, or the cells may die for one reason or another and get reabsorbed, so on and so forth. The state has to have a justifiable reason to not allow the termination of the cells, so to speak. Because we're going back to that whole, it's just a mass of cells argument. Yes. Part 2, state may define the term physician, which almost every state does. In fact, they have a medical board that has to be passed in order for them to have their license, and they have to keep up on continuing education and stuff like that. In Doe versus Bolton, post page 179, procedure requirements. This holding, we feel, is consistent with the relative weights of the respective interests involved, with the lessons and examples of medical legal history, with the litany of the common law, and with demands of the profound problems of present day. The decision leaves the state free to place increasing restrictions on abortion as the period of pregnancy lengthens, so long as those restrictions are tailored to the recognized state interests. The decision vindicates the right of the physician to administer medical treatment according to his professional judgment upon the points where important state interests provide compelling justifications for intervention, saving the life of the mother. What a lot of the pro-abortionists who reference Roe versus Wade don't understand is that written in the judge's decision is the argument that there's a lot we don't know in 1973 about pregnancies and babies and so on and so forth. We are going to rule that, yes, the state has a viable interest. It needs to tailor its interests down to a certain point and justify why. And they also give the argument this case should be revisited as science progresses, science and biology progresses. Up to those points, the abortion decision in all aspects of inherently and primarily a medical decision and basic responsibility for it must rest with the physician. If an individual practitioner abuses this privilege of exercising proper medical judgment, The usual remedies, judicial and intraprofessional, are available. Our conclusion is that Article 1196 is unconstitutional in means. Of course, the Texas abortion statutes as a unit must fall. Because of Article 1196, the entire law has to be stricken as unconstitutional. The exception of Article 1196 cannot be struck down separately, for then the state would be left with a statute prescribing all abortion procedures, no matter how medically urgent the case. Although the district court granted appellant Roe declaratory relief, it stopped short of issuing an injunction. Yeah, it's got something else. It's talking about her no longer being with child. She was not with child at the time of her appeal. In the something that the appeal court said with her not being of child, blah blah blah. If you're really interested, you can go back and look at it, but it kind of goes back to one of the first things that I read to you about justification for the Supreme Court to take the case, even though the appellee is not currently pregnant. This is something that's going to happen again with the amount of time that it takes for a court case, let alone an appeal. The courts are backed up. The initial case, she'll be not pregnant by the time it goes to court anyway, either by miscarriage, by abortion, back abortion one way or another, or by delivery. And then even if that's not the case, by the time it goes to appeal, regardless of which side appeals it, she ain't gonna have a baby. There's just no way. Not in her. And so they expressed even more that by the time it reaches the Supreme Court for consideration, she could be on her third pregnancy if she's pregnant at all. Judgment of district court as to intervener Alford is reversed. This is a guy who he was an abortion physician, and he had done several abortions, been charged and convicted twice, was charged and facing 3 more counts, and was waiting to go to court. He was going to testify or argue with the Supreme Court, or argue at the Supreme Court for Jane Roe. And the court was like, we're not getting involved. You knew what you did. And the guy even admitted that he was facing 3 more cases because apparently he had done 3 more abortions after being charged twice. Okay, whatever, dude. District court is affirmed. Costs are allowed to the appellee, which means state paid Jane Roe's expensive court costs. This is just this is just references and justifications for their ruling as to a butt ton of other court cases and legal briefings. Not all of them are court cases. Some of them are just legal briefings. But there is a ton of them in this. So, yes, for the case of Roe versus Wade, the Supreme Court ruled in favor of Jane Roe. That part's true. And that's the only thing that you hear. That's the only thing the abortion advocates argue. But many of them don't know, as well as the fact that those who do, many of them will not talk about, even when they're asked a question, to be perfectly honest, because I kind of brought this up in one of my criminal justice classes, and they didn't want to talk about it. I had one instructor who said, yes, that's in there. Because of our lack of knowledge and not being able to, in real time, observe the development of a fetus or a child while in the womb, there was debate about exactly when the fetus is considered alive, and that the U.S. Supreme Court, which I've shown you, not word for word, but I've shown you bits and pieces, the U.S. Supreme Court said, we're ruling in favor of Jane Roe, saying that yes, she can have her abortion, even though at that point in time she already had it. But we're also striking down the Texas law for these two reasons in particular. They also argued this case needs to be revisited when science progresses further. And to be honest with you, in relation to the fetal heart bill of both South Carolina as well as the fetal heart bill of Texas, you hear about the one in Texas, you don't hear about the one in South Carolina. But guys, South Carolina, we hear actually passed the fetal heart bill 2-3 months ago. And state Supreme Court was hearing a case because a lot of advocates for abortion were suing, saying that no, it's not constitutional per Roe v. Wade. Again, these are people who've never sat down and read Roe versus Wade. As far as why the Texas one, who was just recently passed, and then somebody else turned around and sued for it to go straight to the Supreme Court. The Supreme Court said, well, there's no reason for us to hear the case. It's constitutional. There's no reason for us to hear the case. This is why. The Texas bill is narrowly tailored as defined and described within this current ruling. Honestly, the South Carolina heartbeat bill is too. And we've got a lot of people here in South Carolina that are up in arms about it. But it's only Texas that they talk about. Well. So that's all I got for you tonight. It's Friday, it's after 8 o'clock, so I'm going to get off of here. Hopefully you guys can go have some fun. I don't know if I'm going to do some reading or if I'm going to watch a movie. Decisions. You guys go check out the store. I'm hoping that y'all find some stuff there that you like. I am still working on more things. I am also very, very open to hearing ideas from you guys. I do have a list of 3 or 4 things from people on Nextdoor before I got kicked off of Nextdoor. But yeah, if you guys have ideas that you would like for me to put up there in the store or whatnot, let me know. I'd love to hear what you have an interest in purchasing so that I can try and help you out. Now, the other thing I will tell you guys is that the prices on some of those, some of the stuff in there, I have put them down as fairly low, I think, or for what I can do. Quite a few of the items I only make a few cents or $1 off of. Trying to make it easier and more affordable for you guys. I keep saying I make $1. Technically, I'm not really making money. I am trying to do this to help fund these projects and platforms, videos, podcasts, writings, and things like that. Majority of it. I want to try and keep all of it going into the platform. Again, excuse me. I want to try and keep all of it going into the platform. But even if I am not able to do that, the majority of it will still go into the platform. It'll be for the podcast, the videos, and so on. And I know I've told you guys about this once before, but I'm going to go ahead and do this again. Or show this to you again. Nope. Yes. Okay, you guys go to anchor.fm, do a search for the Southern Constitutionalist. You have the option here to click support. Now that will stay within the podcast, anything that you guys give there. The other thing is if you want to send me a voice message, click on message. It's not typing. That will be an actual recorded message. Tell me what you think, give me some critiques, whatever. Tell me if you don't mind it going out on the podcast or not. I do need to know that, because if you don't care, I can put it out on the podcast. I can throw it into the podcast and talk about it. If you don't want to be heard, then I will leave it out of the podcast, or leave your voice out of the podcast and try to talk about it or whatnot another way. So yes, that's how you can reach me. As I said, you've got the website. You're doing it through social media. You can comment underneath. And you've got the little message button here. So I'm going to go ahead and get off of here. And until next time, you guys watch your six.